of the commission and to allow everyone to follow, and you can see that we have paginated it, and we also gave it to Mr. Khampepe. So do you have the bundle in front of
Yes,
you,
I
Mr.
do have
Khampepe? Yes, thank you. So you'll see, if you first start with the first page of that bundle, it has got the index there. It has got two of your affidavits that you deposed to. The first one you'll see was deposed on the 18th of March 2026. The second one was on the 10th of July 2026. Do you see that?
Yes, I do.
In addition to the two affidavits, we received the additional documents that appear from item 3 to item 6 from the commission yesterday, which I forwarded to you. Do you recall that?
Yes, I do recall.
And did you have an opportunity to peruse this
Yes,
additional
I did
documents?
peruse them last night.
And you will be able to engage with them in the course of your testimony.
Most definitely.
Thank you very much. So if you turn to the first page, that is page 1, that is your first affidavit, the one that you deposed on the 18th of March 2026. Did you have an opportunity to refresh your memory by looking at this affidavit before you came to this commission today?
Yes, I did.
If you go to the last page of it, which is page 6, there is a signature there. Will you confirm that this is indeed your signature?
This is my signature.
Then if you go back to page 1, it is quite a short affidavit. You, in the first paragraphs of this affidavit, you have given us just a brief synopsis of yourself in terms of who you are, where you attended your schooling and education, and as well as your political activism. So without you having to read these paragraphs, particularly if you look at paragraphs 1 to 3, you have given just a brief synopsis of that. But just for the record and for the benefit of everyone, are you able to just give us just a little glimpse of your background in terms of you as Mr. Khampepe and your education, and as well as your political activism in the past?
Yes, I can. I have a BUris degree that I obtained from the University of Zululand in 1976. And in 1981, I obtained a master's degree in international law in Leipzig University in Germany. And I have been a political activist since my teenage days in Durban. And in 1976, I joined the underground work of the ANC, where I was involved in operations until I went to exile, which I stayed until 1986, when I was arrested here in Johannesburg and sentenced to 10 years on Robben Island.
Sorry, if you could face the chair, sir. As you speak, face the chair.
Oh, sorry.
Is he audible in terms of audibility?
Not only that, at our age, Mr. Khampepe, and we are around the same age, if you could please speak louder.
Okay. Raise your voice, Mr. Khampepe,
Oh,
for the benefit in particular of Advocate Moroka.
I'll try my best. As I was saying, Chairperson, I have a BUris degree from the University of Zululand, which I obtained in 1976. And then later, I obtained a master's degree in international law at Leipzig University in Germany. From a political perspective, I have been a political activist since 1976, having joined the underground work of the ANC, where I operated in Durban and Johannesburg, and later I went to exile. And when I was in exile, I happened to come back to South Africa via Lesotho, where I was based, and I was arrested here in Johannesburg in 1986. And I was sentenced to 10 years to Robben Island under the Internal Security Act. And then when I was released, I then operated as a Project X coordinator for NADEL, the National Association of Democratic Lawyers. I have been a member of the National Executive Committee of the ANC from 1990 until December 2022. And I've also been a member of Cabinet since 1994 until 2019. So that's a brief outline. And also I was the head of ANC policy from 1997 until 2022.
Thank you, Mr. Khampepe. You mentioned in paragraph 5 of your affidavit the context in which you deposed to the affidavit. Do you see your paragraph 5 on page 2?
Yes.
So you say that this was as per the invitation from the Commission to assist it with certain matters which may fall within your personal knowledge at the time when you were the Minister of Justice and Constitutional Development. And in paragraph 1, when you go back to paragraph 1, you do tell us the period within which you served as the Minister of Justice. Do you see that?
Yes, I do see, where I started in May 2009 until May 24th in 2014.
2014, yes. So during your tenure as the Minister of Justice for that duration, you have now deposed to this affidavit in relation to those matters that the Commission has identified, and you have paraphrased them in paragraph 6.1 and 6.2 on page 2. Do you see that?
Yes, I do see.
Can you read 6.1 and 6.2 so that when I engage with you further, we understand the scope and the context in which you deposed to the affidavit?
Yeah, as I say in those paragraphs, when I deposed of this affidavit, I didn't have the benefit of any document from the department. I was reliant on my own memory. That's why I deposed it the way it is appearing in those paragraphs.
Well, you do make that point in paragraph 10 on page 3. If you can read paragraph 10 into the record.
I must state that due to the passage of time, I rely mainly on my recollection of events and interactions with officials of the Department of Justice and Constitutional Development, and do not have the benefit of looking at files that have been processed or in possession of the ministry of the time.
So, must I understand it to be that when you deposed to this affidavit on invitation from the Commission, you did not get the assistance of the department? Because I do understand when one looks at when you have deposed to this affidavit, which was March 2026, you are no longer the Minister of Justice. So did you get the assistance from the department in respect of it availing to you historical documentation that could have rekindled your memory?
No, I did not have any access because at the time I was based in KwaZulu-Natal as the convener of the ANC there. And as you can see in the affidavit, it was deposed off in Umhlanga in Durban. At that time, the official of the TRC commission kept on phoning me with when am I deposing of this affidavit. So it was within that context that I felt it was my responsibility and duty just to rely on my memory and deposed of this affidavit.
Yes. The focus of this commission is the TRC related matters which fell within the purview of the National Prosecuting Authority, which in turn the Minister of Justice, in terms of Section 179, sub 6 of the Constitution, has some oversight role over the NPA. Was that also your understanding?
Yes,
of your
definitely
role?
it was my understanding.
Yes, so in this affidavit, you focused largely on what your role, as you understood it, was in relation to the supervisory powers that the Minister of Justice has over the NPA. Are you able to, just based on your understanding, in simple terms, what you have understood your role to have been in relation to what you are required to do pertaining to the work of the NPA in general, and later we'll narrow it down to the TRC?
Yes, I do know precisely what my role was as a Minister of Justice and Constitutional Development vis-a-vis the role of the NPA and the National Director of Public Prosecution, that as a minister I should not interfere in the prosecutorial decisions of the NDPP. And during my tenure as a Minister of Justice, I never sought to interfere with that, because as a lawyer myself by training, I understood, and also as a political activist, I was always very aware of how during apartheid there was interferences by ministers of justice with magistrate judges and so on. So it was something that was very conscious in my mind.
Yes, thank you. You were not new to knowing about TRC matters because they dated back to the time or before you were the Minister of Justice yourself. So what did you understand your role to have been as the minister in relation to how the NPA was to process the TRC related matters, especially coming from the TRC as the commission at the time?
Well, I knew precisely what the role was, because also as a political activist, I was part and parcel of all these events that unfolded in the 90s, in particular, when I was based in KwaZulu-Natal as the chairperson of the ANC. If I may add, I was particularly very familiar with the Commission's work, because even before the TRC commenced in 1994, 1996, I had been part of a previous commission of the Goldstone Commission where I actually gave evidence on behalf of the ANC about the violence that was taking place in KwaZulu-Natal. So as a Minister of Justice, it was something that was deeply embedded in me, that I should exercise my role and duty as a Minister of Justice without interfering with the prosecutorial decisions of the NPA. And my record speaks for itself, as I will be able to explain during the course of this hearing.
Yes, thank you. If you look at what you say in paragraph 14 of your first affidavit at page 4, you do tell us about your role in the TRC cases and to what date that goes back to. Can you read paragraph 14 into the record and give context to it?
My role in TRC cases dates back to 1 December 1998, when I, together with my comrades, Dr. Ian Phillips and Mr. Sipho Sithole, appeared before retired Judge Selwyn Miller, applying for amnesty for our role as part of the self-defense units in KwaZulu-Natal province during 1990 and 1994. At the end of the hearings, we were all granted amnesty for our respective roles. If I may add, is that I was actually the commander of the self-defense units in Southern Natal, so that's why I felt it was my duty to appear before the TRC Commission to tell them what precisely my role was. That's why I was granted this amnesty.
I see. In paragraph 16, at the bottom of that page, you tell us about what you actually did upon assumption of office as Minister of Justice from 11 May 2009, and you specifically highlight 2 events. Can you tell us about that?
Well, I'm stating in that paragraph that when I assumed my responsibility, many of the activities that I was involved as a Minister of Justice were merely ceremonial in nature, as I will explain in more detail precisely what my role was, because I understood that the actual prosecution of all those who perpetrated crimes against our people was the sole responsibility of the NPA and the prosecutors.
Can you tell us about the 2 ceremonial roles that you played in respect of the TRC matters and why that was significant for you to have highlighted?
Well, as I indicate there, I think it was around 2009, I did go to the Eastern Cape for the exhumation of the bodies of some of the combatants who were assassinated by the apartheid forces. So I was part of that ceremony for the reburial of those which I indicate there, which was the PEPCO 3, Sipho Hashe, Champion Galela, Kakauli Godolozi, and the COSAS 2, Topsy Mdaga, and Siphiwe Mtimkhulu, which was a very moving ceremony in the Eastern Cape. The second one was also in Eastern Cape, about where the remains were excavated at the post-Chalmers farm near Craddock by the Missing Persons Task Team, and I also participated in those as well.
Yes, no, thank you. The first affidavit focused on those two events as the role that you played during your tenure as the Minister of Justice, and also your understanding of your role in terms of Section 179, subsection 6 of the Constitution, and Section 33 of the NPA Act. So, given that the affidavit was quite brief and only focusing on those two matters that I have identified, the Commission requested you to come and give evidence, but if needs be, to supplement your affidavit. Do you recall the invitation?
Yes, I do recall.
And you did supplement your sworn statement or your first affidavit, am I correct?
Yes, that is correct.
If you turn to page 7 of this record, there is a sworn statement by yourself which is somehow detailed. It goes up to page 21, but paginated page 27. If you can go to the last page of your sworn statement. The page will be the signature of the Commissioner of Oath is appended, and your signature appears at the penultimate page 26.
Yes, I do see it.
And you confirm that that is your signature.
Yes, it is my signature.
And this affidavit, you deposed to it on the 10th of July 2026.
Yes, I do recall.
And you also had an opportunity to refresh your memory by looking at it before coming to this commission today.
Yes, sir, I do.
And you confirm the contents of this affidavit
Yes, I do confirm.
and the correctness thereof, and that you have stated those matters which fall within your personal knowledge.
Yes, I do.
And when you deposed to this additional or supplementary statement, did you have the benefit of any material that you may have received from your erstwhile Department of Justice?
No, I did not.
Yes. Now, in this affidavit, you have gone somehow in detail to explain the interface between Section 179 of the Constitution and Section 33 of the NPA Act. You have already testified here that you understood your role or your oversight role as the Minister of Justice to be one of difference. That is, you should not interfere in the workings of the NPA. So I'm not going to say that you should go paragraph by paragraph of this affidavit, because you are largely dwelling on your own understanding of Section 179 of the Constitution and Section 33 of the NPA. But what I'd like to do is to take you to the Act itself, that is the NPA Act, which appears in that same bundle that is before you from page 52. So at page 52, that is where the Act starts, but the relevant Section 33 will be found at page 67.
Yes, I see. Even though the font is very small, but I can still see.
Yes, is it too small for you to read? Otherwise, I can read it out.
Yeah, I can try to read. I still don't wear spectacles.
Yeah, but if it is, then I can read it out for you, and thereafter I'll ask for your comment. So section 33 reads as follows: Minister's final responsibility over prosecuting authority. 1. The minister shall, for purposes of section 179 of the Constitution, this act or any other law concerning the prosecuting authority, exercise final responsibility over the prosecuting authority in accordance with the provisions of this act. 2. To enable the minister to exercise his or her final responsibility over the prosecuting authority as contemplated in section 179 of the Constitution, the National Director shall, at the request of the minister, furnish the minister with information or a report with regard to any case, matter, or subject dealt with by the National Director or a director in the exercise of their powers, the carrying out of their duties and the performance of their functions. B. Provide the minister with reasons for any decision taken by a director in the exercise of his or her powers, the carrying out of his or her duties or the performance of his or her functions. C. Furnish the minister with information with regard to the prosecution policy referred to in section 21(1)(a). D. Furnish the minister with information with regard to the policy directives referred to in section 21(1)(b). E. Submit the reports contemplated in section 34 of them to the minister. And F. Arrange meetings between the minister and members of the prosecuting authority. So when you look at this section, which interfaces with section 179 of the Constitution, it seems to suggest that the final responsibility over the prosecuting authority rests with the minister. And what has been your understanding at that time? That you're sitting now as a minister in your office with executive responsibilities and powers in respect of doing all other things, but among them, you have this section which says that insofar as the NPA is concerned, you have the final responsibility over them. What is your understanding of that?
My understanding was that if for any reason there is an issue that I need to understand as a minister, I can ask the NDPP or any director to furnish me with the report so that I can appraise myself of what the latest developments are. And in fact, I do recall some instance where I did that. For an example, there was a time when I was overseas and I came back on a Saturday morning during the time of a meeting of the National Executive Committee. So when I arrived that morning, the meeting had started the previous day on Friday. And I was informed by one member of the NEC that in my absence, there were some members of the NEC who were very concerned about the prosecution of John Block, who was a chairperson of the ANC in Northern Cape. The concern was that the then National Director of Public Prosecutions, Menzies Milan, had personally gone to court to deal with the matter. So it sort of rattled some feathers there. So I then asked for a report from Menzies what was happening. So he did give me a detailed report about the corruption that was taking place there. And I actually supported him because John Block at the time was a very powerful figure in Northern Cape, and some prosecutors were very hesitant to sort of start the process. So as a leader of the NPA, he took the lead of showing that it can be done. And as we all now know, eventually the said block was convicted and sentenced to 15 years. So it's one instance that I was able to exercise that final responsibility of requesting information as to what is happening. And I did explain to my own comrades there was absolutely nothing wrong that was happening there. The law is the law, as the Germans say. Das Gesetz ist das Gesetz.
Could exercise of final responsibility not have included you having to ask the National Director of Public Prosecutions, why have you, or why are you prosecuting John Block?
Definitely not. I would never ask a question like that. I just wanted information so that those who want to know, I can be able to explain to them, and also to satisfy myself that everything is in accordance with the law. And the other instance, but I never asked that is related to this, that case also involved some ANC leaders in KwaZulu-Natal. They were eventually arrested, and one of them was actually convicted, who was the head of a department in KwaZulu-Natal. So I'm trying to explain that even though this Section 33 indicates that the minister exercises final responsibility, but that can never be construed as meaning that the minister must tell the prosecutor what to do and not to do, and also to choose who are the people who must be. Otherwise, that means the law will be wide open, because justice must always be blind.
So, in simple terms, what is your understanding of final responsibility? Because some may say that the understanding should be that the buck stops with the minister in respect of prosecutorial decisions and otherwise.
Well, I think I was very aware that as a Minister of Justice, it's slightly different from other ministers. For example, I was a Minister of Public Works. I could ask my DG every issue and the reasons why they don't do certain things. But as a Minister of Justice, the yardstick is much stricter and prescribed how to delineate akin to a separation of powers, even though the minister is part of the executive, the NPA is part of the executive, but the operations are different, cannot be the same like a head of department. NPA is independent of the minister.
So what you're suggesting is that final responsibility must be understood in the context of the independence of the NPA in respect of prosecutorial decisions.
Yes, definitely. If I can use maybe, even though it's not comparable, but a much more similar analogy. When I was a Minister of Justice, there was, even though it was not my responsibility, there was a case that ended in the Constitutional Court after the dissolution of the Scorpions and the establishment of now what we know as Hawks. The Constitutional Court ruled that the Hawks were not sufficiently insulated from political interference. So that's why the law had to be changed to make the head of the Hawks to be independent of the Minister of Police. You may ask that what is the difference between the Hawks head and the National Police Commissioner, but as we know, the Constitutional Court is the apex, so they take final decision on disputes. So I'm trying to use that to explain that my understanding was that I can merely ask questions from the NPA, but I can never, ever tell them who to prosecute and who not.
Thank you. In the context of the example you have given about the prosecution of John Block as an example, looking at section 33(2), which says to enable the minister to exercise his or her final responsibility over the prosecuting authority as contemplated in section 179 of the Constitution, the national director shall, at the request of the minister, and furnish an A up to F. Now, in respect of the example you have given us about John Block, where you asked for the report from Mr. Menzies Milani, who was the NDPP at the time, do you recall how that report was asked? Was it in writing, or was it just something where you just pick up the phone and you said, Menzies, what's going on? Can you tell me? Then I hear this or I see this on television.
No, I asked for a meeting with the NDPP Menzies Milani, and he explained to me, so there was no necessity for me to ask him to put it in writing, because I was satisfied with his response and the life went on.
And so that's how you did it. Okay, then I understand that. Now, as I said at the beginning that yesterday you were then furnished with some documentation by the Commission which comes from the NPA, or at least Justice and NPA. I would like us to look at those documentations so that you can be able to give the context to them and also the circumstances under which they arose. The evidence you have given both in your affidavit and today under oath orally is that you assumed office as Minister of Justice on 11 May 2009. Do you recall who you inherited as the NDPP at the time when you arrived?
So, my recollection is that when I arrived, there was an acting NDPP that was advocating Share.
Yes. And by the time you left, how many NDPPs had served under you, or it remained that way? Or then they were changing like that?
They were changing. If you recall that the Minister of Justice has no constitutional or legal authority to appoint the NPA director, national director. That is the sole prerogative of the President as the head of the national executive. So my recollection is that I got there, it was advocating Share, and then it was Menzies Milani, and then acting national director Nomgcobo Chiba, and then ended up with the national director Masa.
Yes. So if you look at page 28 of that bundle,
Which one?
The bundle that is before you, the one that is indexed. If you go to page 28, there is a memorandum dated 2 November 2009.
My bundle is different.
The same bundle which has your affidavits.
Oh. Page.
Page 28.
Yes.
So if you go to, well, you just have to flip over, you'll see it's 29, 30, 31. You'll see that at 31, there is a signature there, and I assume that will be your signature, am I right?
It is my signature.
And the date is the 12th of November 2009.
Yes.
And the comment above it says, I agree with the recommendation. Am I right?
Yes.
Remarks.
So when you go back to where it starts, so at 28 is just showing the signatures of people signing, but the substance is at page 29.
Yes.
So we've been given this memorandum, which is dated the 2nd of November 2009. It tells us what the purpose of it was. Submit to the Minister a copy of the report on government's progress on the implementation of the TRC recommendations, the report, and from there it sets out the background there, and it tells us where it comes from,
Yes.
and it is addressed to you.
Yes.
So on the next page, it then concludes with a recommendation there at the top of it. Under 3, it says, it is recommended that the minister notes the forwarding of 500 copies of the report to the parliamentary officer with a view to table the report in parliament.
Yes.
So you have not dealt with this memorandum in either of your affidavits. So you have already said that you did not have the benefit of documentation from the department. So what I would like to know first is, does this document jack anything in your memory to recall? And if so, because if you look at the year, it was the same year in which you were installed as the Minister of Justice, although you had been installed a few months by that
Yes.
time, because you were installed in in May, and then the memo is in November. So do you have a recollection of this document and the context in which it came, and what was it about in respect of forwarding of 500 copies of the report to parliamentary officer, and so on and so on?
Yes, I
So
do
that
recall
then we
now.
can take it to the next step.
Yes, I do recall.
So you recall this.
Yes, definitely.
So what were these copies about? Do you recall? Because we talk of many copies here, 500 copies made to Parliament, I think some extra copies then to be made for other people and so on. What were these copies for, and what was the relevance of that? Was it something momentous in a sense that memorable or to be remembered easily, or is one of those things that came in the course of the work of the office?
My recollection is that this was a report on the TRC matters that have to be sent to Parliament, so that's why these many copies were printed, and this report was duly submitted to Parliament.
So this was simply then to submit the reports to Parliament and then to approve the making of copies which are sufficient then to be distributed to every member of Parliament.
Correct.
And if you look at page 30, I see that there is some writing there because even the Deputy Minister at the time did sign there at the bottom of page 30. At the time, am I correct that your deputy was Andrew Snell?
Yes. He was my deputy.
Yes, so I see that he signed on the 10th of November 2009, and he wrote there under comments, he says, "We should also be advised whether the minister should consider a media briefing and or a statement in Parliament to coincide with the tabling of the report." So do you recall if this was something that was carried through, or is one of those things which happened many years ago and you can't recall?
I can't really recall whether this was happening, but what I do know is that the report was indeed submitted to Parliament.
Yes. So this is the report that we're able to get, or maybe for present purposes for now, the Commission was able to lay its hands on it in 2009, and we don't see anything after that, but at page 32, some couple of years after, in 2013, we have another memorandum there from the Office of the National Director of Public Prosecutions. Do you see that document?
Yes, I
at
do.
page 32? So if you look at this, it is from the then acting NDPP, Nomngobo Jiba, and is copied to her deputies there, such as Dr. M.S. Ramayite, SC. The subject there is a memorandum to the minister in terms of section 33(2)A of the NPA Act, and we've already gone through that section and we know what it says, and it's addressed to you.
Yes.
So do you recall this document, or it is one of those which came in the course of work that your memory was simply rekindled when it was brought to you yesterday?
Yes, I do recall now this document.
Yes. So it is quite a lengthy document because it seems like, as it says, that it is now a report in terms of section 33(2), and we have looked at the section. It says that the minister will request reports from the NDPP, and it looks like on the 30th of May 2013, the then acting NDPP did submit such a detailed report. So if you can just go, because we don't have to really read it through, you have had an opportunity to look at it. The central theme there, if you look at page 33, at the bottom, is the Truth and Reconciliation Commission, or TRC related matters. Am I right?
Yes.
And when you flip through, you see that towards the end, the acting NDPP also a report to the minister about specific cases at page 40.
Page?
40.
Yes.
It says, cases on hand. The investigation of 12 matters are currently being conducted by the DPCI and managed by the PCLU, and then those cases are mentioned: the Craddock 4 incident, PEPCO 3 incident, disappearance of Nokutula Similani, the Highgate Hotel incident, murder of Vianney, attempted murder of Reverend Frank Chikani, Heidelberg Tavern massacre, St. James Church massacre, Amskachir Philip Powell, murder of Sono and Shabalala, Guguletu 7, Dr. Neil Ajit, and so those are the 12 cases that have been reported to you. And then the conclusion at page 45 then is to say the following. It is recommended that the Honorable Minister bring the contents of this memorandum to the attention of Cabinet. The Minister will be informed of decisions taken in all the matters referred to above. So do you see that recommendation?
Yes, I do.
And as we have looked at page 46, where the signatures appear and yours at the bottom of it, then you approve on the 11th of June. Well, it says 11th July 2013.
Yes, I do.
So, do you have any comment that you want to make in respect of this memo, or let me say this report, because if it is under section 33, then it is a report of this report that was submitted to you by the acting NDPP, and if you have any recollection of where it ended, because it was notify Cabinet about this, and we will inform you about the progress thereafter. And if you recall, if there was a follow-up later where you updated about the progress made in respect of the 12 cases that have been specifically identified in the report.
Well, my recollection, having read this document last night, it does appear that this information was sent, and I assume that the Cabinet memo was prepared and Cabinet was informed, because this was like a progress report on the TRC cases, nothing more.
Yes. So that is what we're able to see in terms of the paper trail, insofar as a report on TRC cases was concerned, because the next one that we have at page 47
Is
dated 12 May 2014, which is now the following year. In paragraph 1 of your first affidavit, you mentioned that you remained Minister of Justice until May 2014. You may not recall the exact date, but this memo at page 48 is dated 12 May 2014. So which seemed to suggest that it could have found you on your door.
Yes, if you see my signature there on page 50, it was on the 20th of May, and I was a Minister of Justice until the 24th of May, because on the 25th I was sworn in as a minister in the presidency.
Oh, I see.
Yeah.
So if you go back to page 48, so this memo, it is a letter to NDPP to request status report on prosecutions relating to matters emanating from the TRC process and update on the work of the missing persons task team. So this, it seems to have been a memo that was prepared for you to approve when I look at it. Am I reading it correctly?
Yes, it emanated from the Director General in my recollections. I assume that there must have been maybe media that was reporting about the lack of progress in these TRC matters, so that's why this letter was addressed. to the NDPP to provide progress or lack of it on these matters?
Yes, because I see under purpose, it says the purpose of this memorandum is to submit to the Minister for his consideration and approval a letter to the National Director of Public Prosecutions requesting a status report on prosecutions in terms of the Priority Crimes Litigation Unit, PCLU, mandate to manage and direct investigations and prosecutions relating to matters emanating from the Truth and Reconciliation Commission process, and an update on the work of the Missing Persons Task Team. And then from there, it gives the background, and from there, it concludes by saying that it is recommended that the Minister approve and sign the letter, the attached letter to the NDPP. So as I've already pointed to you, then on the next page, you approve that because you signed on the 20th of May 2014, and you also sign on the same date at page 57 that letter that was attached to the memo. Do you see that?
Yes, I do see.
So the contents of the letter are quite short. I think we can read them into the record so that you can have a sense of that and comment if needs be. I've noted, and this is addressed to now the substantive NDPP at the time, because you've already testified that the NDPP, the last one who served under you before you left that portfolio was Mr. Ngsana. So you address this letter to him and you say the following: I've noted with concern the apparent lack of progress made by the National Prosecuting Authority's Priority Crimes Litigation Unit in terms of its mandate to manage and direct investigations and prosecutions relating to matters emanating from the Truth and Reconciliation Commission process. You are kindly requested to facilitate the urgent submission of a status report on this matter to my office with emphasis on the reasons for and circumstances surrounding the apparent lack of progress in this regard. In addition, I request an update on the work of the Missing Persons Task Team regarding investigations and exhumations in respect of missing persons reported to the TRC. I can only assume that given that you signed this letter on the 20th of May and you left that portfolio on the 24th of May of that year, you did not get a response or an update.
No, I did not get a response.
Because you're left with just a mere 4 days
Yes.
in that position. But then the letter, nevertheless, was written. Maybe if you can give us a context in which this letter was written, would I be correct to say that I sense some sense of frustration on your part about the lack of progress in the TRC matters? And if I'm correct, then what motivated that or brought about that frustration?
Well, my recollection after reading this letter last night was that during that time, the Director General, Ms. Sindane, was briefing me. I think we're in Cape Town about lack of progress on these matters. So I assume that some information had emanated to her that things were not moving as fast as we had expected. So that's why this letter was written. And I signed it on the 20th because I always believe that you are a minister until the last moment of your responsibility.
Taking into account the role of the minister in terms of Section 33(2) of the NPA Act, what could you have done as a minister other than that which we see from this document, where you say that there is lack of progress? And if there is lack of progress indeed, then it seems there was. What could you have done within the parameters of what Section 33 empowers you to do?
Well, other than to ask a comprehensive report from the National Director, maybe the worst scenario if I had received a report that was also very unsatisfactory, maybe the only resort was maybe to change the national director and appoint people who can expedite these matters. But as I say, it was late in the day when this was brought to my attention, as I was really on the departure lounge of justice and constitutional development.
Well, even on that, the Minister of Justice has no power to replace the NDPP,
But
irrespective
I
how
could have
how
asked the
happy you
president
could.
to
So the best you
intervene.
could do is simply to ask the president and say
Yeah.
that we're not getting any joy in terms of performance of statutory obligations by this person. Can you consider maybe replacing this person? So that's the best you could do.
Yeah.
But then, let's say maybe, and this is now hypothetical, they came to the minister and they said, well, we're not making headway in terms of gathering evidence, or we're struggling to locate witnesses in respect of prosecuting the following cases, A, B, or C. Within the context of Section 33(2), will it be open to you to say, well, if you're struggling with that, then stop it. Stop these prosecutions because it's a waste of time and money? Or could you even say that, forge ahead, or the best you could do is simply to say, okay, no, I understand the frustrations that you have, but you must take whatever decision that is in the best interest of the Constitution and what you are obliged to do. So what, in such a situation, as a Minister of Justice, you are required to do to just ensure that you also become satisfied yourself that I am performing that oversight role given to me by Section 33 of the Constitution of the NPA Act?
Let me start by saying that it's very difficult to deal with this matter in a hypothetical manner. As they always say, the benefit of hindsight is a perfect science. But my recollection is that these matters were generally very difficult to resolve, in the main that many of these offenses happened long ago in the 80s, and some of the perpetrators were already no longer with us, they were deceased. Other cases, my recollection, had prescribed, and so forth and so forth. So it was very difficult. But in some instances, perhaps, as I say, even though I'm very reluctant to answer a hypothetical question, if there had been maybe dereliction of duty, I would have taken upon myself to approach the appointing authority, which in this instance is the president, to intervene in order to ensure that it is corrected. But as I say, I cannot recall with specificity as to what actually happened, because this matter happened long ago when I was a Minister of Justice. But the role of the Minister of Justice is very limited in prosecuting matters, as one cannot be seen to be interfering with the independence of the NPA.
Yes, no, thanks. From your evidence, you're quite steadfast about the independence, the prosecutorial independence of the NPA, and in order to demonstrate that you're not simply paying lip service to it, but you are living it, you gave us one example, of course, of how you handled the matter involving one of, or a high-profile ANC leader, John Block. Do you have other instances that you are able to share with us where you are able to say that it was a demonstration of my understanding of prosecutorial independence, that I, as a minister, have to protect it at all costs?
Well, I can't recall any specific incidents other than that of John Block. The other one that I can recall, as I said, was a case in KwaZulu-Natal where some prominent members of the ANC were arrested on a similar matter. I think the media used to call it the Amigos trial, where some MECs were actually arrested. I don't know what eventually happened, but my recollection is that one top member, who was the head of Department 1, Shabalala, was actually convicted, and my recollection is that he's still in jail as we speak. So I've always opposed to corruption of any form as an individual, and also as a trained lawyer, and also as part of those people who were fighting to remove this system of apartheid. And I always believed that good corporate governance in South Africa is the separation of powers. So the one branch of government must not interfere with the other part of the government. So that's why even now I detest people who want us to go back to supremacy of parliament instead of a constitutional democracy, because that's how matters of this nature of interfering with one branch of the law, and also prosecutors start with simple things that appear innocent, but deep, when you look inside it, are people who want to do bad for the country.
Okay, thank you. The primary focal point of the Commission's terms of reference is to investigate efforts that are set or may have been made, or attempts that may have been made by some people to subvert or even interfere with the prosecution or investigation of TRC matters. Do you know of any attempts that came to your attention as the Minister of Justice at the time of attempting to derail investigations of TRC matters or the prosecution of such matters?
I have no personal knowledge of any information about interference or attempted interference in matters of prosecutions during my tenure as a Minister of Justice or any other time since I became member of Cabinet in 1994. I only became aware of this when this TRC process under Justice Khampepe appeared in the media. But as a person, no one has ever approached me to say there is any interference or accusing anybody, to my knowledge.
Thank you, Chairperson. That will be the evidence of Mr. Khampepe.
Thank you, Mr. Mukhari. Ms. Moroka? Is it your colleague? Thank you.
Thank you, Chair. We don't have questions for this.
Thank you.
Thank you.
Mr. Lukele? Oh, he's not here. Anyone online?
Thank you, Chair. Ms. Mchizana, we have no questions for the witness.
Thank you, Ms. Mchizana.
Thank you, Chair. Mr. Lukele, no questions for the NPA.
Thank you, Mr. Lukele.
Thank you, Chair. Mr. Koto, we have no questions for this witness.
Thank you, Ms. Rokhoto. Mr. Vani?
Chairperson, we will apply to cross-examine this witness.
Yes. and your application will be lodged when, Mr. Vani? If you can give an indication.
We will undertake to lodge the application early next week.
Early next week?
Yes.
So it will be before Wednesday?
Before Wednesday, Chairperson.
Thank you. Wednesday will be the 5th of
I think that's
August.
correct, Chairperson.
Thank
yes.
you. Mr. Siminya?
Chair, for that reason, We will defer any questions to the witness until cross-examination is done.
Thank you.
Good afternoon, Mr. Khampepe.
Good afternoon, Justice.
It's been a while.
Indeed, from the TRC.
Yes. Chair, I will ask the evidence leaders that in the interim, they make available to Mr. Khampepe the communication of Minister Bridget Mabandla, where we say that, or where it is stated that some moratorium of some sort was imposed, and also the address of President Mbeki in April 2003. I would want to get some input from former Minister Khampepe on that. I don't want to deal with it now because it would be too perfunctory. We should treat it and give it the weight it deserves. I'm addressing myself to the lead investigator, Advocate Semenya SC. Thank you, Chair.
Chair, if I might ask, because language is important, and DJ JP Khumbu keeps reminding us about English. It is very important for us to understand we don't represent the Minister Bridget Mabandla, but we do represent the ministry. So language, when you say correspondence about the moratorium, we would want clarity as to what the Commissioner means and what he's specifically referring to. We have not heard of a moratorium, but we do have the relationship and the conversations between Ramaite and the minister, and we want us to be very clear about what words we use to describe that. Thank you, Chair.
Well, the lead investigator understands, and you will get that.
That's not my objection, Commissioner Cho.
Are you questioning me?
That's not my objection. I'm objecting to because it reflects what you are saying as a commissioner to the evidence leaders about what Ms. Mabandla said. And it's very important that we say exactly what she said. So when you refer to the evidence leaders and say, we must have this information, it's either in the form of evidence or in the form of correspondence, and what it was about. There was no weight there that said moratorium. That's my concern. To say the evidence leaders understand, that's not the issue that I'm raising.
I don't know where you have been. I've said my say. I'm not here to account to you on this aspect. Thank you, Chair.
Yes. Mr. Semenya, you do understand what is being required of the evidence leaders?
Chair, I will also, in that regard, confer with Ms. Moroka to make certain what documents the Commissioner is referring to.
Yes. Thank you.
Mr. Khampepe, can you hear me?
Yes, Advocate, I do.
Could I take you to page 48 of the bundle? So this is a letter which you've already dealt with. It's a ministerial memo. And if you look under paragraph 2, it says the TRC unit has been requested by the Director General to prepare a letter to the NDPP on behalf of the Minister requesting the reasons for the lack of progress on TRC-related prosecutions and an update.
Yes.
And you say the DG at the time was Ms. Sendane.
Yes.
Now, we've heard from several Directors General over the years, and they say that they had no role to play in the TRC prosecutions. Now, I know this was a long time ago, but what business would Ms. Sendane have had to request you to write a letter requiring an update on TRC cases? Would that have formed part of her duties?
Yes, I do believe, because as the head of department, if something has been brought to her attention that required the attention of the minister, I think it empowers me as the executive authority in terms of Section 33 of the NPA Act to ask for information from the National Director. So that's the context in which this...
Now, I accept your context. Trying to understand what the role of the DG was over TRC matters.
So my understanding is that the DG is like an accounting officer. So as a minister, even though I can write direct to an NDPP, but for administrative purposes, I cannot bypass the Director General because he's the head of department, and in terms of the law, she was the accounting officer.
So how would that have related to TRC cases?
I regard that as any other matter, so long as it is not being construed as an interference, because the memo is very straightforward. It's seeking information from the NDPP to provide information on the TRC matters and the missing task team.
So you say that somebody must have brought matters to her attention, which is why she brought it to you.
Yes.
Okay. I'm not suggesting that there was any interference. It's in the context of the evidence we've heard from DGs who have all said we had no role to play in the TRC matters. That's why I was curious about why the DG was writing to you. That's the context of my question.
My DG, Sindani, was also a trained lawyer, actually, and she understood corporate governance, especially as she was also a former company secretary of a AMSCO.
Understood, thank you.
Yes.
Then could I take you to the report on page 32?
Yes.
And this was a ministerial memorandum from Advocate Jiba sent to you on the 30th of May 2013.
Yes.
And if you turn to page 38, you will see in her report let's start with paragraph 5.16. As a result, 350 of the 400 cases were finalized. In respect of the remaining 50, further investigations were necessary before the decisions whether or not to prosecute could be taken.
Yes.
Now, in your understanding as the Minister of Justice, who was responsible for the investigation of the TRC cases?
My understanding is that in the main it was the police,
Please.
but I could not recall specifically which division of the police, but the responsibility of investigations fell within the ambit of the SAPS.
She says, thank you, she says at 517, both the DSO and SAPS were requested to investigate the remaining 50 cases but declined to do so.
Yes.
Now this was before your time, so do you have any knowledge of this?
No, I don't have knowledge of that.
Do you have any knowledge of the matters in 5.19, where she says the formulation of guidelines took a considerable amount of time? Once they entered into laws, they placed the decision on making decisions whether or not to prosecute on the NDPP. Any knowledge of that?
No, I can't recall that.
Any knowledge of the task team referred to in 5.20?
No.
And I suppose nothing in your recollection of 5.21?
Yes, correct.
Okay. So I take it then that up to 5.29, these were all before your time.
Yes, even though Advocate Mshe was there for a very short period during my time, but I don't recall these matters, except the report that they sent to me.
Okay. And while you were the Minister of Justice, were you aware of any problems regarding the investigation or the prosecution of TRC cases?
No, not at all, except towards the end of my tenure, when Ms. Sindane brought to my attention. That's why I signed that letter to the NDPP on the 20th of May 2014.
Okay. Thank you very much.
Thanks.
Mr. Mkari?
Nothing from our side arising from the
Yes.
questions asked.
Yes. You'll wait for cross-examination.
We'll wait for the cross-examination
Yes.
time when it,
Yes.
yes.
Mr. Khampepe, we thank you for having come before this commission to give evidence.
Thanks, Justice Khampepe.
Yes. As you have heard, an application for your cross-examination is going to be launched before this commission, at which stage you will be required to return for such cross-examination. But for now, you are excused as a witness.
Thank you, Justice. Anytime, I'm at your service.
Thank you very much.
Thanks.
These proceedings are adjourned until the 4th of August at 10 o'clock.